Let's talk now about the weaponry given to attorneys in law school for treating expert witnesses during cross-examination. Some of these techniques may not apply to you or even to your sphere of expertise, but they are common approaches used by attorneys. Give them some thought and prepare to handle questions based on these approaches. There is no particular order to these questions. They may ask you all of them, or only some of them, and not in any particular order. The best way to defend against probable attacks during cross-examination is to become familiar with the most common forms and to understand the examining attorney's goals. Having answers to those expected questions will reduce your stress and minimize the likelihood of falling prey to well-known cross-examination methods. You'll find that sometimes attorneys can use your own prior work against you. Attorneys with the same inclination toward thoroughness and preparedness as you will do their homework before questioning you. They will discover things about you and your previous work, as well as any testimonial efforts in several ways. Knowing what attorneys look for and what they may discover can certainly help you to plan. You can take the following steps that a methodical opposing attorney might take. He may ask his own expert what the expert knows about you in your mutual specialty. He may ask and speak to other attorneys who either worked with or against you in previous cases. He may assign support staff or hire graduate students in your field just to learn of any weaknesses you may have professionally. Now, to do so, those people may first obtain copies of advertising you've used to promote your services. Second, they may search publications in your specialty for quotations from you, or even from your colleagues at the same company or school where you work or worked. Third, they may find and review your previous writings and testimony. You should realize that even though Rule 26 requires you to disclose publications in the last 10 years and testimony in the last 4 years, attorneys are not at all constrained to only asking you questions solely within the scope of those years. If their research finds that you have previous publications or previous testimony earlier than that, they may ask you questions about anything they find in those previous writings and testimony. Next, these people may look for contradictory public remarks on issues similar to this case that may have appeared in the body of any speeches or seminars that you may have delivered or even have scheduled for delivery. They also may use search engines to find websites that reference your name. Then, they can look for any discrepancies between credentials listed there and on your current CV that you've submitted to the court. And finally, they may learn the names of existing peer-reviewed publications in your field. You should be aware of the existence of these publications as well as what they may say about the methodologies you used. As a key tactic then, in an effort to use Daubert criteria to challenge the admissibility of your testimony, attorneys will look for relevant articles that discuss whatever methodologies you have used. You cannot rely on incomplete or evasive answers about your own methodologies as compared to the authoritative ones discussed in those publications. Knowing about the existence of such articles will help you anticipate questions during cross-examination. In addition, if you have done this research effort before you even reach your own investigation and reporting phase, much earlier in the case, you will have made your earlier work even more solid. Now, as to attacking your qualifications and testimony, during cross-examination, opposing attorneys will consider attacking both of them, qualifications, your credentials, Perhaps your degrees were not directly relevant to this case. Perhaps you did not even complete a degree program. Perhaps your experience in the industry was not quite on target for the elements of this case. Perhaps your experience or degrees seem out of date. What have you done recently that is directly related to the specific case about which you are opining? Perhaps there were time gaps in your professional work experience. What were you doing during those gaps? Are there any discrepancies between your CV and the credentials listed on your business website or your university's website? You should prepare reasonable answers to any of these kinds of questions that you can expect about your own qualifications and credentials. You should assume that they will see or discover opportunities for attack here. You should not ignore any weakness in your qualifications and credentials, and you should discuss any such weakness in advance with your retaining attorney. He may well want to consider addressing the weakness in some fashion to minimize it in advance during direct testimony. Next, they will almost always attack you for any possible form of bias. Perhaps you always work for the defense or always work for the plaintiff. Perhaps you have worked often for this particular law firm that hired you. Perhaps you have written something that expresses a clear-cut advocacy for a cause that's connected to this case. Perhaps you have just written something silly but relevant and now public on your Facebook or LinkedIn or Twitter account. Think ahead to what possible opportunities may exist for attempting to convince the jury that your testimony is slanted. You should prepare answers to all of those efforts to paint you as a biased or less professional expert.